did I already do any of the sentencing, or did I just let you guys kind of know that I was leaning towards probation and that we needed to have?
I know it's indicated on January 26th of this year, we appeared, we discussed the PSI. There was a disagreement as to the restitution. The court says that it was inclined to place the defendant on a current probation, given the length of time between office date and the indictment. Then fast forward to February the 9th of 26. The case was simply just reset for restitution hearing. So it looks like you didn't do anything.
You can feel the judge trying to piece this case back together in real time. That's never a comfortable sign for a defendant. When a court has to stop and clarify whether sentencing even happened yet, it tells you this case has had a messy procedural history from the jump. But notice something important here. The judge isn't rushing. She's carefully rebuilding the timeline before making a decision that could literally send someone to jail. And honestly, that patience may end up saving the defendant later.
They haven't actually sentenced yet.
I don't believe he did, Judge.
Okay. And have you, all right, ma'am, you're Janisha Leonard. And Miss Leonard's here in 3 cases. One is cause number 25 DCCR 0297. That is the new theft of property case, a state jail felony she entered plea of guilty to. And then we have 2 MTRPs, one in cause number 19-33340, theft of property, and 20-36095, a theft of service.
The last information I have in my files is that she was on a straight post-conviction probation. I don't know if she initially was on deferred or not.
Yeah.
I don't know.
All right. Yeah. Okay. So the biggest issue, one of the bigger issues that I had when we were here for sentencing, based just on paper and the appearance of this, I don't disagree with Mr. Coleman's assessment of the case, with the criminal history of Miss Leonard with these types of offenses, and which the criminal history.
This is a huge legal moment that most people miss. The judge is basically drawing a hard boundary around the indictment dates. Translation: even if prosecutors suspect a much larger theft scheme, the court can only directly calculate restitution tied to the charged time frame. That's Criminal Procedure 101. Prosecutors can't just casually expand the allegations midstream. But here's the twist. Even if the judge limits the restitution amount legally, she can still consider the bigger alleged pattern when deciding punishment. And trust me, that distinction is about to matter a lot.
Is these 3 cases. There aren't any other cases. And the new offense date was August of 23. And kind of just unknown, it sounds like, why that case was delayed in prosecution. Doesn't look like anybody knows. And so the time frame between that and now, and the lack of any other cases while Miss Leonard has been out and on probation during that time and doing well, it looks like otherwise on probation, is what leads me to potentially move forward with continuing the probation potentially on the others and giving her a probation on this one. So there was no agreement on any of these, but it looks like there was an issue.
Okay, this is the moment the courtroom energy completely changes. Up until now, this sounded like a routine theft case. But once the store manager breaks down the alleged system, reprinting receipts, voiding transactions, removing cash, suddenly this feels less like an impulsive mistake and more like a long-running operation. And you can actually hear the prosecution leaning into that narrative hard. The question now becomes, does the judge see someone capable of rehabilitation, or someone who mastered the system and abused trust repeatedly?
Issue with regard to the amount of restitution. So let's go forward with that. Have you guys come to any type of agreement on the restitution?
We are very
far apart, Judge. And I guess one of the issues that we have is I believe Mr. Coleman's got some exhibits that are going to go back to 2022. I would object to looking at anything outside the range in the indictment. The indictment goes from August 23, let me get to the exact piece.
Let me get it pulled up as well.
August 24th, 23 to September 4th, 23.
Okay,
I would ask that we remain in that range.
I would think legally that would be probably what I would need to do.
Judge, it's a continuing course of conduct. The theft is. I'll be honest, Mr. Ross just brought that to my attention this morning. I haven't had a chance to research it, but
Oof, this is bad timing for the defense. The judge was clearly leaning toward probation earlier, but now she's discovering incomplete community service, unpaid restitution, and poor compliance while already on probation. In courtroom terms, that's like showing up to a job interview with a resume full of red flags. Judges can forgive mistakes, but they absolutely hate seeing someone waste prior opportunities. Do you think the defendant still deserves another chance at this point? Let me know below.
He certainly has had all of the restitution information showing that it's going back to 2022 in the discussion. So it's not an unfair surprise for him to know that we're looking for restitution going back.
Well, but I think the allegations, and obviously I understand the honor about as well as any of you guys, but those are some pretty specific. I mean, that's a very short time frame that is alleged in the indictment. Talking what, 4 days?
Well,
5 days?
Yeah,
Well, yeah,
from August 24th, 2023 to September 4th.
I'm sorry, I'm looking at an old indictment. I'm sorry, hold on. I was looking at another
About
case.
10 days, maybe.
Hold on. So in the new calls number.
This is the emotional turning point of the hearing, and whether you believe her or not, this kind of allocution matters. Judges hear facts all day long, but moments like this are where they evaluate sincerity, accountability, and future risk. The defense is betting heavily on rehabilitation here. Stable job, motherhood, no new allegations in years. But prosecutors are focused on pattern, deception, and repeated theft offenses. Two completely different stories about the same person, and now the judge has to decide which one she believes.
So yeah, this one is August 24th, 2023, September 4th, 2023. So less than a couple of weeks or so is the allegation. And I don't want to have to keep coming back here. But I think to go back, if it was a few weeks off, a month or two off, but if we're talking years requesting that, then I think that indictment needs to allege, and so we can go forward with that time frame today. Legally, that's where we need to be.
And there it is, final warning shot. This wasn't a soft probation sentence. This was the judge basically saying, I'm giving you one last lifeline, and I expect perfection. Zero tolerance probation is brutal, because even small violations can trigger serious consequences. And notice how personal the judge makes it at the end. You don't want to be back in front of me, because I remember you now. That's courtroom language for the grace period is officially over.
She's already pled to it, late to amend the indictment. So with regard to the time frame of August 24th through September 4th, 2023, is what is the amount between that time frame? Do you guys have that? Okay, we're back on the record. 25 BCCR 0297 19 340 320 095. Y'all have an opportunity to kind of go back through the receipts as far as legally that we can talk about on this case.
Mr. Coleman came up with a number $2,407. In speaking with Ms. Lynch, her recollection